Directive Principle of State Policy. The Directive Principles of State Policy seek to realize the ideals of justice, liberty, equality and fraternity enshrined in the Constitution. The Directive Principles of State Policy are contained in Part 4 of the Constitution. This idea was borrowed from the Constitution of Irish Republic. Though the Directive Principles are not enforceable through the courts, still they are regarded as fundamental to the governance of the country and have to be kept in mind by the state while framing the laws and formulating the policy. The Directive Principles can be broadly divided into three categories, viz. Socialistic, Liberal and Gandhian. Directive Principles of State Policy differ from fundamental rights in many respects. First, the fundamental rights are negative injunctions to state, while Directive Principles of State Policy are positive instructions to the state. Secondly, fundamental rights are justiciable while Directive Principles are not justiciable. Third, in case of conflict between two, the fundamental rights are given precedence. Despite the above limitations of the Directive Principles of State Policy, their importance cannot be denied. They are as much a part of the Constitution as any other provision, and their violation is as much unconstitutional as violation of any other provision. Further, if the government acts contrary to the Directive Principles, its act can be declared as unconstitutional. Again, if the people take keen interest in the Directive Principles, the government cannot afford to ignore them. Supreme Court and High Courts have also attached great importance to some of the Directive Principles and tried to enforce them. So far they do not come in conflict with the fundamental rights.